Okay, everyone, we are back. And just give me a moment. Bobby Gebbia, did you need to speak with your client?
No, Judge, we went over the PSI and the TAP already.
And who is the prosecutor on James Brewer?
Meredith, I think, was handling it this morning.
Right. Is that Mr. Brewer in the courtroom? All right, are the deputies in the courtroom?
Yes, ma'am, I'm here.
All right, Mr. Brewer, if you can come forward, please.
Right here. I think they'll be able to see you. Stand right there and just stay still. You're good. You want, you can pull down your mask so you don't sound all off.
No, you're using the wrong camera. He needs to be on the 187. You're showing him on, just 1 second, let me see.
He's on there, Judge.
Okay, awesome. All right, thank you. All right, and Mr. Gebbia, if you could show your video, please. All right, the court is calling 2020 CR 0778, State of Texas versus James Edwin Brewer. Can I have parties announced for the record for the state?
Meredith McIntyre for the state.
For the defense?
Robert Gebbia for the defense.
And are you James Edwin Brewer?
Yes, ma'am. Yes, Your Honor.
All right, we're proceeding by video because of the pandemic. The court will note for the record that the defendant is in the courtroom. Any objections to us proceeding by video, state?
No, Your Honor.
Defense?
No, Your Honor.
Mr. Brewer, do you have any objections to us proceeding by video?
No, ma'am. No, Your Honor.
All right, you entered a plea on July 27th. To count one, you entered a plea of no contest. The state waived count two in the habitual offender paragraph without objection. The court found there was sufficient evidence to find you guilty. The court requested a TAP evaluation and a PSI. Have both parties had a chance to review the PSI report, state?
Yes, Judge.
Defense?
Yes, I have, Your Honor.
All right, any objections to the PSI report, state?
No, Your Honor.
Any objections from the defense to the PSI report?
Yes, Judge, we have one objection or correction, and we're going to note it here for you on the gang affiliation.
Yes.
I don't know if it's a typo or if that's information that the PSI officer derived from somewhere that I don't have access to, but Mr. Brewer denies ever being affiliated with the Aryan Brotherhood gang.
Okay, the court will take note of that. And according to the plea bargaining agreement, the state is requesting your punishment be assessed at a cap of 6 years in the prison. The state opposes your application for deferred adjudication or community supervision, and there's to be restitution to Enterprise Rent a Car. Off the record for one moment, Mr. Finch, did you have a chance to continue speaking with your client?
I did, Your Honor, and we just need to have a hearing on those motions for bonds.
All right. I know you have to go somewhere, and what time do you need to be out of this court?
By 3, Judge, I can let you can handle this procedure. I'll wait.
All right, thank you. All right, state you're opposed. You may proceed.
Yes, Judge. Based on what you can see in the PSI report, this defendant has a lengthy criminal history. He is, as you are well aware, a habitual offender. We did waive that as part of the plea bargain. But if you look, he's been on felony community supervision 4 times, and each time, all 4, he has been revoked. We don't believe he's a good candidate for community supervision, and this is why we made an opposed offer.
All right, defense.
Judge, I think that we have to balance really what the facts of this case are versus his criminal history. Sure, he does have an extensive criminal history. We understand that. We knew going into it. His first conviction was 22. He's now 53 years of age. when him and I discuss it, and when we talk about it, what we talk about a lot is, a lengthy substance abuse history. And he mentions that in the TAP evaluation, which recommends an outpatient substance abuse treatment facility. He mentions that he has been sober now for some time, which is great for him. Look at what we have here, Judge. $380 some odd dollars in restitution. I don't know if anybody should have to go to prison over $380, and it seems like we are, to a certain extent, holding his criminal history against him, and that's what we do. But if you're looking at this factual basis, what we have here, he rented a car. He was in a really bad spot. At the time, he was homeless. At the time, he was addicted to drugs. This is some time ago now. This is June of 2019, right? So now we're 2 years down the road. Here we are in September now of 2021. So this is a long time ago. Sending somebody to the prison for renting a car and not returning it, to me, I think is a little bit much. I understand that he has a significant history, but then look at the dollar amount that Enterprise Rent-A-Car is out, and it's $380 that they're asking for in restitution. To me, I think that the facts of this particular setup, the way that we're set up here, and we're looking at sending this man away, incarcerating him for a certain period of time, I understand what he did in the past is bad, and all of this stuff doesn't look great. I don't see really too much real horrible stuff here, robbery, aggravated robbery, and those types of things. These are kind of petty theft crimes that seem to be going on for a significant amount of time. He has been to prison before. Judge, I just ask you not to send him this time. Give him a good shot at doing right. He's sober for what appears to be at least one of the first times in his life. He's got a good family around him. He's employed, which makes me very proud of him. He's making a good wage at this point now. He's making over $4,000 a month. He seems to be doing good. Let's give him the opportunity to show this court that he can do good and can change, right? I mean, that's what ultimately we want out of people, is to do better and to change. And it looks like, he hasn't done a great job in the past. We get that. Maybe 50, 53 now. Maybe now is Mr. Brewer's opportunity to show everybody that he could do right. There was no damage to the vehicle. They got their vehicle back. He was extremely desperate at the time, which he's expressed to me many times. I mean, who would want to be in a position where they're addicted to drugs and renting a car under a fake name and living out of it, right? It's a bad situation, but that's where he was. Now he has his family. He has a good job, and I think that he can do well. He's taken responsibility for what he's done. He is deeply remorseful. He's always been deeply remorseful to me. I would have hoped that we would have gotten a better plea bargain for him, but this was the best that we were able to do. I think the opposed is a little harsh. I think 6 years is way too long for this type of behavior. Judge, I think we give him the opportunity to be supervised and the opportunity to do right. And I think that he can do well for you, Judge. I do. And he's willing to drug test today. He's been sober for some time now.
I want this issue addressed here. The defendant told police he rented the vehicle with fraudulent identification card and that he uses fraudulent identifications for different things.
Yeah, I think that in my opinion, the way that I read that as, that's kind of what his history has been. He's been in trouble in the past for this type of fraud and this type of theft activity. It's probably how he was getting by when he was using meth, right? That's not uncommon for people who are addicted to meth to use fake IDs and to do those types of things. If you look at his criminal history, right, you have failure to identify, tampering with the government record, which is probably something similar, a couple of other forgeries, tampering with evidence, fabricating evidence, forgery. That's kind of the MO that he's been operating under. Now, some of this stuff is pretty old, right? I mean, going back to when he was 22, we got 2004 all the way up through 2012. He hasn't been in trouble in some time, so that's good. I think I see something here that was dismissed in Tom Green County, but otherwise he hasn't really run afoul of the law in a little while. Some of this stuff goes back to 1990, which is a very long time ago. But I think that what you're reading there in that PSI, Your Honor, is him, right away accepting responsibility, right away assisting law enforcement in their investigation, being open and honest. And this is kind of how he was living when he was on the streets and when he was really in a bad spot. Life has turned around for him and he's doing much better now. Of course, that doesn't excuse criminal behavior, but he has taken responsibility for it. He knows that he's done wrong. And when we look at this period of behavior, this renting a car and not returning it, I don't want to, say that it's nothing, because obviously it's something and he has a history, but it is kind of a benign offense, Your Honor. And I think he is a person that there is still good in him that we could get him back on the right track here.
All right, state.
Your Honor, the state has a different interpretation of these set of facts, as I'm sure defense and Your Honor can imagine. One, I don't believe that the offenses in his past are just no big deal. He does have weapons offenses that he was sentenced on, felon in possession of a firearm, theft of a firearm, things like that. And he does have a pattern of not only stealing, but using other people's identification, which is a whole nother crime in and of itself. In the current offense, if you look at the PSI in his interview, in defendant's interview, he says that drugs played no part in this current offense. So if drugs don't play a part in it, then he just has a tendency to just steal things, whether or not he is sober or not. So I don't know that that's going to make a difference. I do agree with Mr. Gebbia that this theft, in terms of the actual restitution amount, is not as large as perhaps other thefts, but that's not excusing the behavior. And that's why we did the plea bargain that we did, Judge. We capped it at 6 years. He technically could have had way more than that. So now Your Honor is looking at a range between 2 and 6, and we do not believe he's going to be a good candidate for community supervision, and we ask that you deny the application.
Where is your client? Oh, Mr. Brewer would like to say something.
Yes, Your Honor, and I understand.
Well, let me swear you in.
I'm sorry.
Could you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is James Edwin Brewer. And I can understand where the prosecuting attorney, where she's coming from and whatnot. And all I can say is I have owned up to my past, my wrongs. I'm asking for another chance. I said, I got my life back on track. I got a good job. I'm doing the right thing the right way. And I don't know if I have it in me for another deal to go back to prison. I've already lost everything 5 or 6 times, but I'm doing the right thing this time, the right way.
But the 5 or 6 times that you lost everything, whose fault has that been?
That's mine. I'm not blaming anything on anybody but myself. But I'm asking you, as an older gentleman now, will you please give me another chance? That's all. That's all
All
I'm
right.
asking.
Anything else from the defense or any questions for the defendant?
No, Your Honor.
State any questions?
No, Your Honor.
All right, so this is what the court wants. I want a UA from Mr. Brewer today. Number 1. Number 2, I want proof of his employment. Number 3, I want proof that he's had this heart surgery or something that was mentioned in the report. I want proof of that. So when can I have proof of these things? The UA is happening today.
I have proof in my wallet about my stents in my heart. I have that on my wallet right now.
Well, I mean, you need to talk to your defense attorney, but my question is proof of employment and all of that. When am I getting that?
Well, I could get all that to you right away, Judge.
All right.
If all goes well, I could get it to you by the, without question, by the end of the week. I'm going to try and get it to you by the end of the day.
All right, so this is what I want. I want that information. Mr. Brewer is going to do a UA today, Rebecca. There will be no excuses for you not doing that UA today.
Yes,
And we're going to come back on Friday and I will make my decision on Friday. I'm not saying that I'm going to give you deferred. I'm not saying I'm going to give you probation. I'm not saying I'm going to give you prison. I'm just saying I would like some more information so that I can make a decision and find out where you are in your life at this point in time. Do you understand?
Yes, Your Honor.
Norma, can we come back on Friday on this case?
Yes, ma'am.
Rebecca, would that give you enough time to get the results?
Yes, it should be plenty of time.
All right, and I want him tested for meth and also cocaine and marijuana and alcohol. Now, before I send you for this test, are you going to test positive for anything?
No, ma'am, shoot, no,
I'm sorry?
no, ma'am. I take my medication for my heart, but that don't have nothing to do with it, no, ma'am.
Okay. So we're going to see what the results are. When you go to do your UA, you need to bring your medication and let them know what you're taking. So I'll see you back on Friday. I'm going to send you to a breakout room with probation. Mr. Gebbia, you can go to breakout room number 1. And to the courtroom, if you could go to number 1, please. All right, Mr. Finch.
Yes, Your Honor.
Just one second, I'm sorry. Oh, so in the 187 District Court, you should have where you're listed as courtroom and just take that room to number 1. Thank you. All right. Tom Nesbitt, are you going to be handling these motions? Are you ready to handle the motions on the motion to set bond?
Yeah, Judge, I'll have a brief argument from the state, and I'm sure defense will have a brief argument, and then the court can just make its decision. Am I muted? No.
Oh, no, you're not. All right, the court is calling 2021 CR 8077B, 2021 CR 8064B, 2021 CR 8065B, 2021 CR 8076B, 2021 CR 8072, State of Texas versus Joseph Ramirez. Could I have parties announced for the record for the state,
Tom Nisbet for the state.
for the defense?
Your Honor, Matthew Finch on behalf of Mr. Ramirez, we're ready.
And are you Mr. Ramirez?
Yes, ma'am, I am.
Judge, you
We're
might
proceeding.
also have to, I'm sorry to interrupt, you might also have to set on a nightmag cause number as well.
All right,
Yes.
to the clerks. There should be some bond motions on Mr. Ramirez that are nightmag numbers, please.
Yes, Judge, I'll check.
All right, and the court, that would just be one nightmag case, and that's 611070. Is it more than one?
Oh, Your Honor,
No,
that is
that's
correct,
it.
and that's the case number.
Yep.
Okay. All right, and also nightmag number 611070, which is a family violence case. Joe Ray or David Martin, are you available?
I'll just make the argument, Judge.
All right, thank you. All right, we're proceeding by video because of the pandemic. Any objections from the state?
None.
Any objections from the defense?
No, Your Honor.
Mr. Ramirez, do you have any objections with this proceeding by video?
No, ma'am.
All right, the defense has filed motions in each of these cause numbers to set bond. State, are you ready to proceed on the motions?
Yes.
All right, defense, it's your motion. You may proceed.
Thank you, Your Honor. If I may, just to make a brief argument, Your Honor, my client has quite a few cases pending. Obviously, my client had made bond on all of the cases through no fault of his own. The bondsman on all of these cases has filed an affidavit that was granted earlier this month. And on to all of the cases that are called before you today, my client has been remanded without bond and has been in custody since about the 16th of this month. Your Honor, my client is in touch with his family. He might have some resources to make some new bonds. We would just ask, in light of the fact that he is remanded without bond and is in custody, we'd ask that you set the bonds in each of these cases. We would ask that you set them at a minimum to what they were prior. He will have to engage new bondsmen to post the bond, but we would ask that you consider setting the bonds in all of these cases so that he can try to make arrangements to get out on those bonds. I'll also point out, Your Honor, there were no any pretrial violations or anything like that that I'm aware of, other than the allegations of new cases, obviously. But as far if there were any reporting requirements or anything else, I am not aware of any of those issues. But my client is sitting in custody And we would ask that he have that opportunity to make bonds on all these cases. There are a couple of cases, Judge, that there are still bonds set. From what I can tell, one of them's a misdemeanor offense and the other one is an indicted case.
Which indicted case does he have a bond on?
Your Honor, according to the Bexar County website, it's that 2021 CR 8084B. It's a tampering government record case, and my notes show that he has a $15,000 bond on that case. And I intentionally did not file a motion because that bond is still set.
All right, State.
Yes, Judge, a couple issues, sort of taking up where defense left off on the no fault of his own. We would just give a timeline to the court. So since this defendant was placed on bond in this honorable court, June 27th of 2020, for 2 felony offenses, he has picked up 6 new cases, 5 of them felonies, and that is across 5 different offense dates. The court can now take a sort of global perspective, looking at the cumulative situation with the dates of this defendant. Other than that 8084B, which is right now a standing $15,000 bond, and a misdemeanor, which the court doesn't have to decide, we would ask for $20,000 per case.
All right, so what is the alleged offense date on 8064B?
8064B or
Yes.
84B?
No, 8064B, 2021 8064B.
64B is June 27th, 2020.
And then 8065B.
June 27th, 2020.
And then 8076B.
76B is October 13th, 2020.
And then 872. I'm sorry, 8072.
8072. Oh,
Oh, it's 2021 CR 807.
here it is. Here it is. I'm sorry, Judge. Yes, October 28th, 2020.
And then cause number 2021 8077B.
77B is December 16th, 2020.
And then night mag number 611070.
April 18th, 2021.
All right, defense, it's your motion, so I'll give you final argument.
Your Honor, again, I just re-urge, even if you set each of the bonds on this case at $10,000, my client will have to come up with at least $80,000 worth of bonds. The court is also able to assess any additional conditions of bond to ensure that that he's able to stay out of trouble. We would just ask that you set the bonds. I understand the situation, the several different cases and the offense dates, but I would ask that you consider setting them at between $5,000 and $10,000 a piece so that he is able to contact a bondsman to attempt to get out on bond.
All right, in cause number 2021 CR 8046B, I'll set the bond at the original amount of $10,000. And in cause number 2021 CR 8065B, I'll set the bond at the original amount of $10,000. In cause number 2021 CR 8076B, I'm going to set the bond at $15,000.
I think you're done.
And cause number 2021 CR 8072, I'm going to set his bond at $15,000. And cause number 2021 CR 877B. Court will set his bond at $15,000. And cause and night bag number 611070. Court will set its bond at 15,000. All right, is there anything else from either side?
Not regarding this motion, Your Honor, no. But you did recall us, Your Honor, later this month for a setting, and I have a couple of different dates. Could you confirm what setting for these cases?
It was going to be recalled for October 25th.
Thank you, Your Honor.
And Mr. Ramirez, my understanding, an offer was tendered in each of these cases. Are you rejecting that offer?
No, ma'am.
Are you accepting?
Yes, I don't understand. I didn't hear you, ma'am.
Oh, I'm sorry. The state has made an offer, correct? Yes or no?
Yes.
All right, I don't want to know what the offer is. What I want to know is, are you accepting that offer? Are you telling the state you do not want that offer?
No, ma'am, I'm not accepting the offer.
Okay, I just wanted to make sure that was clear so I can put it on my docketing sheet that you're rejecting the offer. All right, we'll be back on October 25th, Mr. Ramirez.
Yes,
And
ma'am.
at that time, if you're planning on hiring an attorney, you need to have your attorney here on that date. You understand?
That was the 25th, ma'am, you said?
Yes, October
Yes.
25th.
Yes, ma'am, I'll make sure.
All right, thank you.
No, thank you very much, Your Honor.
You're welcome.
Mr. Finch, thank you, sir.
Have you excused? Thank you, Mr. Ramirez.
Yes.
Y'all be
Thank
safe.
you.
Thanks, Tom. Y'all be safe.
All right, thank you. You too. Or Norma, you can let them know that Mr. Ramirez can go back.
Yes, ma'am.
Yes, ma'am.
And if everyone will just give me a moment, please. And Norma, can you make sure in the system that it has Mr. Ramirez set for October 25th in all of these cases? Because I see where he was originally going to be set for October 19th.
Yes, ma'am.
All right, the next case we have up is Matthew Velasquez. Are all the parties ready?
Yes, the state's ready. We have our victims on Zoom as well.
Okay. And this is just for sentencing, correct?
Yes, Judge.
All right, the court is calling 2020 CR 12351, State of Texas versus Matthew Velasquez. Can I have parties announced for the record for the state,
Meredith McIntyre for the state.
for the defense?
Sergio Ibarra for Mr. Velasquez.
We're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, ma'am.
And are you Mr. Velasquez?
Yes, ma'am.
Do you have any objections with us proceeding by video?
No, ma'am.
You entered a plea of no contest to count one on August 30th. The court found there was sufficient evidence. The court found you guilty of count one, ordered a TAP evaluation. The state waived count two without objection. According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. There's no application for deferred adjudication. The state recommends community supervision. And there should be restitution, if any, to Griselda Flores and to the San Antonio Police Department for blood testing. Have both parties had a chance to review the PSI report? State,
Yes, Judge.
defense,
Yes, ma'am, we have.
any objections to the PSI report? State,
No, Your Honor.
any objections from the defense to the PSI report?
We do have some things we'd like to address, Judge, regarding the recommendations and some of the material that was in there. But short of that, no other objections.
All right, state, you may proceed.
Your Honor, in this case, after careful consideration and meetings with the victim's family and multiple conversations back and forth that look at the evidence, we felt that the best path forward, despite the gravity of this offense, was a recommendation of probation for a long period of time so that this defendant, who is young, who does not have criminal history, could get his life together and hopefully turn his life around despite this terrible tragedy. The only thing the state would say after reviewing the PSI, and obviously defense will have a chance to speak to this because I understand there was additional information that they submitted. The state was a little disappointed in the way that the defendant talked about some of the offenses. I don't know if that was just a strategic move, but according to the PSI, he doesn't believe he needs help. At this point, the state feels like he needs more supervision than outpatient based on some of those answers. And obviously defense can speak to that, but either way, this is a gift he's been given. And we want to make sure that for the safety of the community, that he has the proper tools in place to be successful on community supervision.
All right, and defense?
Your Honor, we very much agree, and Matthew agrees with the notion that this is God's grace and a blessing that he has been given a recommendation of probation. And he understands, and something that he was very important to him was to make sure that I addressed the role that Aldo Rey's family played in the state coming to this decision, and he does not take that lightly. One thing I want to say, just to be very clear about this, is that I know that Matthew was not being evasive in this interview whatsoever, or trying to avoid responsibility. Having spoken to him at least half a dozen times by Zoom and in person, and his mother and his father being in meetings with me, we've been very, very involved with each other during the pendency of this case. It took him a long time to warm up to me. When I tell the court that he is shy, that is truly an understatement. I think that there is a nice gooey center within him that we've kind of gotten to, but he comes from, I have family from the same area. He comes from an area where I think it is impressed upon people that expressing your emotions is like imposing upon them. Country folks aren't quite like city folks, and Uvalde's not a small town, but it's not a big town either. And that's where he's from. But he has always been very direct. When we first met, I was very clear to him. I was like, always be very direct with me, always be honest in any of your interactions. And he's taking that to heart. We've had some very frank and very productive conversations throughout this, in which he's expressed just the extreme level of remorse that is in the packet that we've sent the court regarding this sentencing. I almost feel embarrassed to say this, but I'll tell the court exactly what my instructions were to him. I know that he gets nervous when he speaks. And so I told him, I remember I have a note about it. It says, I told him, whatever you do, be honest, be yourself. And if you were asked a question that you don't have a good answer to, don't speculate. Don't add anything to it if you don't know something. And I think he took that quite literally in the interview. His parents happened to both be in the interview when he was there. They're here in the office along with us two. And they were able to kind of explain how things went. His father had even told me that at a certain point, she was asking him, the person doing the interview, about his hobbies. And his dad kind of had to prompt him, because he was very quiet and almost like a deer in the headlights. And he's like, talking about fishing and baseball. Oh, and he's like, okay, fishing and baseball. It was that type of thing where I think that he was not trying to be evasive whatsoever. That is not the Matthew that I know. And as evidenced by the letters that were provided to the court, that's not the Matthew that he is. And so it's always nerve-wracking to get these reports that can't give you the nuance that is what reality has regularly. So I wanted the court to be very aware of that. We had a meeting yesterday about all aspects of this, and I want you to know that he was very clear that whatever is asked of him, he'd gladly take on. He feels that he can learn from every single aspect of this. And so I don't think what he was trying to do was avoid or be strategic whatsoever when it comes to not needing to do anything. I think he was just trying to follow my instructions. And him being young and not much of a talker, I think he just was very straightforward on that. I don't think there's any indication in the PSI that he was trying to avoid any interpretation that or impression that he was not using, or that he wants to use, or that he doesn't want to take on any responsibility for this. I think quite the opposite, Judge. Regarding the recommendations of that's happened in the PSI, I can tell the court that on several different occasions, it has been very clearly said to me, and I believe it wholeheartedly, he will never drink alcohol ever again. He will never use an illicit substance. What I put in the summary that was put on the sentencing memorandum is very true, which is we said it like this yesterday. Every person has a cross to bear. A lot of people go through miserable times trying to find their purpose. And part of the blessings of this, along with Aldo Rey's family being so gracious, is he knows now what his purpose is in life. And that is to live his life in honor of his best friend and make every single decision in his life with that in mind. And he's a very stoic person. I've met his dad, and it's very much like that too. And I know that I can hear him getting emotional next to me, which is a lot. I can tell the court. But that is who is sitting beside him. One part of this that I think was important, that his mother and father, who are here, and his siblings are in here as well, especially him. It was interesting. I was, as an attorney, you try to sit and say, like, I'm here to talk about all the great things about you. And he was very much like, we don't have to talk so much about all these great things. I'd rather we focus on Aldo Rey and how great he was. And I was like, well, it doesn't quite work like that. Like, I'm going to have to say some things on your behalf. And he understands that part of it, but that spoke volumes to me about who he is. He is a very quiet person. And as we've gotten to have these conversations, the thing that really spurred everything on for us to be able to have more clear dialogues is when I just asked him, why don't you just tell me about what it was like growing up with Aldo Ray? And that's when he really started talking. He became animated. It just flowed after that point. And, I was sitting down trying to take as many notes as possible about little things that they had done. And I tried to put a little bit of that in the summary. And you may see that in the letters that are before you, Your Honor. But they were there for each other. And to be the cause of the loss of someone that special, you better believe that he's never going to forget that. And that is going to be the engine which keeps him completely on track, well beyond the ending of community supervision. I do not believe that an inpatient or a facility is going to serve him on. I don't think that it's as necessary as maybe the state mentioned. I do believe that he will take on an intensive outpatient treatment with Verve. I think he's going to do very well with that. When he said to the PSI officer, it was interesting because they were explaining to me how the interview went. It was a lot more open, and his nerves. I think his mother, who's here, can vouch for this. That the interviewer said, "I can tell he's very shy," but he was trying to be very clear about not wanting to say things that weren't true, and that he does not use. When asked about whether he has a substance abuse problem, there's always that part of me that wants us to play the game, so to speak. Where it's like, well, say that you do. Say that you do. It sounds good. It sounds, but I've asked him several different times, and I do believe it to be true, and I think the court will see this. He does not use and will not use any substances at all. It's that simple for him, but he will gladly do anything asked of him by the court. I think the last thing I really wanted to say is, two things. One is that he mentioned that, there was a part of him that really wanted to, sometimes just wanted to die, to look away from all of this. And he himself was the one that said he knew he needed to face it and walk toward it. And the one thing he wanted to say that I thought was moving to me is he said decades from now, even when he's an old man, if Aldo Ray's family ever decided that they wanted to speak to him, needed something from him, he would always be there. It's a very poetic thing to come from a person like him, and I believe it. I think that's all I have, Judge.
Anything else from the state?
No, Your Honor, we just ask that you follow the recommendations for some sort of inpatient treatment. I think that's the only thing we're disagreeing on at this point. We do have victim impact statements later, but that's it from the state at this point.
I'm sorry, Your Honor, there is one more thing, I'm sorry, that I need to address, and I believe I had a conversation that went with the state at this, and I think we're in agreement in asking the court. As far as the 120-day jail provisions in the statute. We are asking, because he's been on house arrest during the entire pendency of this case. We ask that he be allowed to continue on ELM so he keeps his job and is able to enroll in school and continue as he's doing in Uvalde. He's been going on the straight and narrow and been doing quite a bit to make sure that everything is that he's getting a move on when it comes to taking care of his responsibilities.
Mr. Velasquez, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Can you state your name for the record, please?
Matthew Velasquez.
All right, if you're drug tested today, and when I say drug tested, I mean drug tested for marijuana, alcohol, cocaine, any type of drug that is illegal, what are the results going to be?
Clean.
All right, when's the last time you used marijuana?
The night before the accident.
All right, anybody else have any other questions?
Your Honor, the state does.
Yes.
Mr. Velasquez, in the PSI report, when you were answering questions, the PSI officer, and they asked you to talk about the accident, you said, "I can't remember." Is that correct? Is that what you said? That's all you said about this accident?
Yes, ma'am.
Okay, and is that really the case? You can't remember a single thing about the accident?
I can.
I'm sorry, I couldn't hear you. Can you say that again?
I can.
You can,
Yes, ma'am.
but you chose not to provide that information in the PSI report to the judge?
Yes, ma'am.
Okay, and is it still your testimony that you do not have a problem with substances at all?
To be honest.
Yes, no, sir.
She's asking, is it still?
Mr. Velasquez, you need to make sure you answer the question that's being asked of you.
Yes, ma'am.
He just asked me, Judge, to I guess explain the question, but if you want to ask it again, Meredith, I'm sorry.
I'll try asking it again. Mr. Velasquez, you told the PSI officer that you did not have a problem with substances at all. Is that still what you're telling this court?
Yes, ma'am.
Okay, but you understand that because of the graciousness of the Flores family, you're getting an opportunity to stay out of prison and be on probation for intoxication manslaughter. You understand that, right?
Yes, ma'am.
And substances did play a part in this accident, correct?
Yes, ma'am.
So it would make sense that as part of your probation, you would need to go through extensive therapy to treat your addiction issues, correct?
Yes, ma'am.
Okay, no further questions, Judge.
Okay. I read in the defense's packet that the defendant is from Uvalde. Is he living in Uvalde? Is he not living in Uvalde?
He is, Your Honor. He lives with his father in Uvalde.
All right, this is what the court is going to do. As previously stated, the court found you guilty. The court will sentence you to 10 years in prison, suspended and probated for 10 years. $1,500 fine probated. Restitution, if any, to Griselda Flores and to SAPD for blood testing. 200 hours of community service restitution. The court will waive 40 of those hours if you have obtained the COVID vaccine and provide proof of that to probation. The court is not requiring that anyone get the COVID vaccine, but if you have obtained it or at any point, if you produce that to probation. Then probation will deduct 40 hours of community service restitution hours. The court will not allow the defendant to buy out the remaining of those hours. So the remaining of the hours will have to do those, Mr. Velasquez. 200 days GPS in lieu of 120 days in the Bexar County Jail due to the COVID pandemic. DWI education, VIP live. Ignition interlock. Does anyone want to speak on the terms of ignition interlock? The state is requesting half.
Your Honor, we had a short conversation about that some time ago during our conferences, and of course, we're fine with doing whatever the court sees fit on that. What we would ask, just because of the expense, and we understand part of that, is to be able to have maybe an assessment scheduled when the court sees fit, maybe every 2 years, maybe every year after 2 years, or after half of the term, I'm sorry. So maybe have an assessment done at half the term or before that point, whatever the court thinks is.
Okay, because the court was thinking that maybe ignition interlock may need to be longer.
I
So
see.
the court will order ignition interlock for half the term. And at that time, we can have a review. Defense, you'll need to file a motion. And what I'm going to put on here is I'm ordering ignition interlock, period. And I'm not ordering it for half the term. I'm just ordering ignition interlock. But I will note that at half term, defense, you can file a motion. Make sure the state is served with your motion, and we'll see where we are at that time.
Yes, ma'am. Thank you.
We're going to do regular UAs for 90 days. I'm sorry. Sometimes I can't read my writing. It's just regular UAs. And 90 days driver's license suspension. Are you asking that the probation be transferred to Uvalde?
We are, Your Honor.
All right, transfer probation to Uvalde, Texas. What county is that?
It's Uvalde County.
Ha! Brenda, now everybody know I'm not originally from Texas. I deal with parishes. So transfer to Uvalde, Texas. However, Mr. Velasquez, you are not supervised or transferred to Uvalde, Texas until they accept you there. There's going to be regular reporting by Zoom. If for any reason you can't report by Zoom, then it'll need to be in person. I'm going to want field visits 2 times per month, random. Proof of employment. Within 30 days. No employment as a home healthcare provider or with minors. Do you have any children, Mr. Velasquez?
No, ma'am.
Rebecca, is there anything else that I'm sorry. We're going to start you off on intensive outpatient treatment and see where we are after a significant period of time. Rebecca, is there anything else that Mr. Velasquez needs?
No, ma'am.
Mr. Velasquez, is there anything else that you need in order to be successful in this probation?
No, ma'am.
Mr. Velasquez, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Velasquez, this is why I tell people time and time again, if you're going to drink, don't drive. Don't be a designated driver if you're going to drink. And if somebody's driving, somebody needs to be the person who says they're going to be the designated driver and they don't drink at all. I'm always the designated driver because I don't drink. I think it tastes nasty. But now you're in a situation where you don't have your best friend anymore because one, somebody decided to give you alcohol. You're underage. And then you decided to take alcohol. And then we're here today with an accident. Nobody, and I think I can safely say this, it's an assumption on my part. I don't think anybody ever takes a drink of alcohol and thinks, I'm taking a drink of alcohol so I can get in the car and kill somebody, especially not their best friend. But we're here because you decided to drink and drive. All right, Meredith, who's here for victim impact?
We have Aldo Ray's parents, Judge. It's under Griselda Flores.
Okay. All right, Mr. Velasquez, the Floreses are going to speak to you, hear what they're saying, and internalize it. Do you understand?
Yes, ma'am.
And I'm going to remove myself from the spotlight and remove Brenna from the spotlight so you can focus on them, okay?
Yes, ma'am.
All right, the Floreses, you may proceed if you will unmute. If you could unmute yourself, please. There you are.
Okay, here we are. Okay. I'll go first. It's a long one. Apologize. Honestly, Matthew, I don't think that there is anything that I could say to make our circumstances any better. And there's no nice way of me stating what I have to say without feeling, or without you feeling a bit of a sting in your soul. Our son, our brother, grandson, nephew, cousin, godson, godbrother, your best friend, and longtime childhood friend are basically our sunshine. The reason we breathe, he was our everything, our gift, and of course, our prince. He's gone. A piece of our heart was taken early Sunday morning when you refused to let someone else take the wheel. We will never be the same. The decision you made in that split second has changed our lives forever, along with your families. Matthew, know that you have a second chance. We don't have a second chance, but you, Raul, and your families do. This is just a bump on the road for you all. You can get up and dust yourself off and try again. This is your chance to make up for your mistake. Do something about it and show us your worth. What would Aldo be doing now? I'm sure making something of himself, because that was his biggest goal in life, to become someone and prove to many of us that he was going to be a successful businessman and a millionaire. And we all know that he would have fulfilled that dream if he had the chance. He was a go-getter and beyond intelligent. We all know that game is over for Aldo, but not you. You're lucky because you have the second chance to make something of yourself. Your mother and father are lucky because they will hopefully see you graduate from college, or perhaps watch you earn a career if you decide to go a different route. Your mother will have that last mother and son dance at your wedding. Your father will get to smoke a cigar or drink beer when your first child is born. Your sister will get a chance to spoil your children and be the best Thea ever, but Gabby won't. Your brother will go to play ball with his niece and nephew. And again, Gabby won't. All that was taken away from us when you took the keys away from Raul, the sober one. I don't know if he was really frightened or just plain dumb. Theo, as he called you. Aldo was your childhood friend since the age of 4. I looked through his photo box and there are hundreds of pictures of you and him. He was more than a friend. He was your brother and looked after you and kept you out of trouble. I know that he was not in talking terms with you for a while because you had done him wrong, but he made amends with you and was able to forgive you before he left us. You were so damn lucky, and there must be a reason why he chose to forgive you. You got a farewell and was able to spend the last days of his life with him. All I got was a silly text asking for money. When you called me that night and said he was with you, I wondered why, but I didn't make a big deal because the fact that he called me and told me his plans for that night was enough for me. Perhaps I let my guard down that night, only God knows. I can't remain angry with you because we both know that my son would not have it. He was the good guy, the one who made sure everyone was included in the plan. According to him, no one should ever be left out. All were welcome and accepted in his small dynasty. He was your go-to and protector for many years, and we know he defended you on several occasions. He never left you hanging. 2 weeks before his passing, he made sure you made it home safe twice. You were lucky to have a friend like my son. He saved you, and you owe him. You owe us. Eric and Alfred, you owe us too. I ask that you put all things aside and take care of your children. They're still young and need your guidance, that you step up to the plate and guide them in the right direction. Don't let them stray. When you brought them into this world, they became your priority. You must put other things aside and nurture them into responsible adults. Your son was lost, and now he is broken because he will have to live with the fact that he is the reason our boy, his friend, is gone forever. Take care of him and make sure that he gets it together. He should not be a burden to you all or anyone. Matthew, know that I don't hate you, and I pray for you because my boy loved his friends more than anything in the world. You were blessed to be loved by such a great man. I hope you know that Aldo has been watching over you these past 19 months. I'm a strong believer of signs, and not once has he sent me one of hate or vengeance. I feel nothing but pain and pity for you. I know for a fact that if Aldo was in your shoes, he would not be able to live with himself. When we were asked for our opinion in the case, my first thought was Aldo. What would I want for my son if he was in your shoes? I would want the pain and the sorrow to be lifted off his shoulders and to truly be forgiven for his mistake. I would not want him locked up and changed forever. No one deserves to live with such pain and guilt. Matthew, the one thing that truly bothers me is that he died alone and no one reached out to hold him. My boy died alone and I did not get to hold him or see him. According to witnesses, you did not approach his body, but yet he ceased to leave your side. You're truly blessed to have an angel like Aldo. Today you are saved by him once again. Perhaps one day I will get the accounts of my boy's last day from you and Raul. You both owe us that much. And next time you decide to drink, remember that you are the reason Aldo won't be able to give you a lift anywhere. The worst part of all this is living the rest of our lives without our son and brother. The fact that it will be a long time before we meet again, because Griselda has a lot of people that depend on her. The pain and emptiness is unbearable, something I would not wish my worst enemy. Bless you, Matthew, and the Velasquez family. You are very lucky to have each other.
Matthew,
Yes, sir.
not a day goes by
that I don't remember that phone call. In that instance, everything was taken from me. You changed so many lives. You changed mine. I will never be the same. The only reason that we went through this plea bargain is because I did not want to put my family through the trial of seeing photos of Alder A. If it was up to me, we would have gone to trial, but I had to think of my family. You have a second chance, Matthew. Make the best of it. And when your attorney says that it may be decades and decades before we can talk, that's me. Maybe my wife can talk to you sooner, but I don't know if I can. Take care of yourself and do good in your life. God bless you.
All right, Meredith, is there anyone else?
I don't believe so, right, Griselda?
No, Gabriela, I don't think so.
All right, let me check. I'll check to see if there's anyone else on the screen. And there's someone here listed as Gabby.
Yes.
G-A-B-Y.
Yes, that's her. That's her sister.
Did Gabby wish to speak or no?
I don't think so, ma'am.
All right. Gabby, if you wish to speak, you can unmute yourself, but if you do not wish to speak, then I'm going to allow Mr. Velasquez to go to the breakout room with probation. Do y'all know if she wishes to speak or no? Meredith or the Floreses?
Yeah.
Because I know sometimes people can't work the equipment correctly.
No, she's not.
Okay. All right, then, Mr. Velasquez, I'm going to send you to a breakout room with probation. Probation is going to go over the conditions with you. And Mr. Velasquez, I know it goes without saying, you're not to drink any alcohol for the duration of this probation. And marijuana, that's a no-no. I know that they're doing different things in other states, but here in Texas, that's not allowed. So there's no vaping, no coming back to this court saying it was CBC, my retainers, telling me that it was some type of oil. You're not allowed to do that. Do you understand?
Yes, ma'am.
All right, I'm going to send you to breakout room number 2 with probation, and probation will go over conditions with you.
Thank you.
All right.
Your
And
Honor,
with, yes,
can I be put into a breakout room with Griselda and her husband?
yes, I'll send you to breakout room number 3. And I'll send Gabby to number 3 as well. So Gabby, if you know how to go to number 3, and I'm just calling you Gabby because that's the way you're listed on the screen. And Norma, I believe that's it for us today. Is that correct?
Yes, ma'am.
All right, everyone. Then we are going to sign off.
Hey, Judge, I had to log back on, so I'm not a co-host. I don't see anything.
Oh, okay, let me make you a co-host.
Thank you.
And everyone, we're going to call it a day. We'll be back tomorrow at 9 a.m. David Martin, I know you're leaving us, but I think you'll be here with us tomorrow, at least. Is he off in space? David Martin, hey.
No, not today. I'm here.
All right. All right, everyone, then we're going to sign off. Bye, Joe Ray. Bye, David Martin, Tom Nesbitt.
Am I the only one that wanted to order some food from Matthew Finch? He looked like a drive-through window guy with his headset.
Hey, we're still live. But I didn't think about that, but okay, guys, I'm going to sign us off live.